Everybody, I'd like to welcome you to this licensing meeting on Monday, the 8th of April. This meeting is being live streamed, so should we lose the live stream, I will pause the meeting until the live stream is reconnected. Thank you. We'll now move on to the agenda. Agenda item 1, apologies and substitutions.
Thank you, Chair. We have apologies from Councillor Kelly Pettit, and Councillor Alan Sharp is here as a substitute.
Thank you. Oh, sorry, Mark.
There are also apologies from Councillor Alison Whelan as well.
Thank you. Thank you. Do we have any declarations of interest? No, and we have, oh, I beg your pardon.
The only thing I'd say is my husband holds the licence for alcohol sales and things, primarily for Littleport Leisure, but very little activity
yes.
goes on at the moment.
I don't think anything that would exclude you from any discussions or voting. Thank you, Councillor Ambrose Smith. Are we happy with the minutes of the previous licensing meeting held on the 14th of February? And you're happy for me to sign those as a true record when this meeting is concluded? I have no chairman's announcements, so we will now move on to agenda item 5, which is the enforcement policy. Over to you, Stuart.
Thank you, Chair. So this item is to consider the adoption of an updated licence enforcement policy. The background to this is essentially the Council, as members know, administers and enforces a large range of legislation intended to protect public safety and local economies and the environment from adverse effects from licensable activities. So it could be taxi drivers, but it can also be Licensing Act, which covers alcohol, entertainment, late night refreshment, but scrap metal dealing. And there's a whole range of legislation that we enforce, and some of those I've listed. So the Local Government Miscellaneous Provisions Act 1976, which oversees taxi licensing, as well as the Town Police Clauses Act 1847. It's hard to believe that's still the one we rely on, but it is, and that's for hackney carriages. And then we go on to more modern ones, such as the Licensing Act and the Gambling Act and the Animal Welfare licensing activities involving animals, England regs, and as I say, scrap metal dealers. That's not an exhaustive list. It's just indicative of what we do as a department. Most of those, not all, but most of the work we do, they have specific policies that we use, and they are there as a framework for officers. They're there for members. They're also there for members of the public, obviously, and applicants, so everybody knows, what they have to do, and also say what they have to do to get the license, but what they have to do to remain licensed as well, because we obviously do take action, and that's what this policy is designed to help with. So an enforcement audit was conducted in 2023 and found that whilst the council had an overarching enforcement protocol published in 2014, the specific license enforcement policy, which was published on the council's website, was actually last updated in 2006. I'm not quite sure how that slipped through the net. I can only apologise for it under my tenure, which has been since 2015. But yes, it was in a far-flung part of the website that we had overlooked. So apologies to members for that. That policy is contained in this report, so everybody can, see it and see what the differences are and to the proposal. So say, having reviewed that content into the 2006 version, officers drafted an updated and simplified enforcement policy for members' consideration. That's contained in Appendix 2 to the report. The new policy covers all the same areas of the 2006 version. Apart from, members will note that Appendix A and Appendix B were removed from the proposed version. So the conclusion is that many of the specific policies and guidance documents maintained by the licensing authority cover enforcement options that are applicable to that specific type of permission. So even though this policy, is very much out of date, obviously, from 2006, the individual policies in the main areas that we deal with have got enforcement parts and provisions within them. So, please rest assured on that. So the proposed policy has been written to take into account the information that is in those other policies, and it's been written hopefully in a language that's a bit sort of easy for everybody to understand. Appendix A and B, as I say, were removed. It was considered that Appendix A is outdated and surplus to requirements due to the content of the proposed policy, and Appendix B was outdated and was very much specific to the Licensing Act 2003. And officers consider that if it is to be updated, that document should be made to apply across more areas and sit as a standalone document, a sort of memorandum of understanding between different authorities. And as I say in my report, that would require a separate piece of work, which could obviously come back to a future committee. I don't think it's best for it to sit within this particular document. There are no financial implications with this. This is just part of what we do in amongst the fees that we generate across the board. So the recommendation is to adopt the proposed enforcement policy, but that's the end of my report, Chair, and I'm available for questions.
Thank you, Stuart. Does anybody have any questions for Stuart? Councillor Inskip, your finger was up first.
Yeah, I've got a few. I guess the first one is on the recommendation, because so the proposal is just to adopt the policy. Now, I was looking around at other authorities that had updated policies. I noticed a number of them actually had a two-stage process. They had a draft policy and then they sent that out for consultation, and then they agreed the policy at a subsequent meeting. And I know we've done that with some other policies, just trying to understand why we're taking a different approach.
No, it's a good point, and you're right. With just about every policy which is under the specific piece of legislation, then there is that two-stage process where we would bring the recommendation forward, and normally that recommendation would be to go for a 6-week consultation, let's say, to enable members of the public to have obviously an input, as well as members of the trade, etc. With this one, the recommendation wasn't to do that because it's kind of, in my opinion, was sort of sat above the specific ones of each individual regime, and it was more that it was how we're going to go about, and it's more a statement of fact rather than rather than like a normal policy decision where there are factors going to change which would have an impact on license holders or applicants, whereas this is just more about how we're going to treat those people, and it is in that way more of a fact-based sort of statement and very legalistic in its way. So if members wish for that to happen, this is only a recommendation, so members can propose to go to consultation if they feel that they would prefer. But that's the reason why I hadn't put that in my report, because I felt that this was more of a headline policy as opposed to one which deals with the specific sort of taxi regime or the Licensing Act sort of regime. If that answers questions, but certainly it's obviously for members to decide and instruct as they feel fit.
Yeah, yeah. Thanks for the explanation. I'll come back to that because maybe when we get to the debate, because as I say, I looked around. So as an example, I guess the nearest one that's happened recently was West Suffolk. So when West Suffolk was created, the two constituency authorities had different policies. They created a new one for the new authority, and they did consult on that. Another one I noticed was Dacorum, which has a very similarly worded policy, and again they went through that process. Okay, so two other questions I've got then, and this is more just in terms of the legislation we're referencing in there. So one is the question is whether we should be referencing, because we do talk in the policy about maintaining records, whether we should then be referencing the Data Protection Act 2018. And on the Equality side, whether we should be referencing the Equalities Act 2010.
Councillor, is there any particular paragraph where you feel that should be?
On the first one, because we're talking about maintaining records, so if I'll find the, I'll see if I can find the record again. Here we are. If we look at paragraph 3.7.
What page is that, Mark?
Oh, good question.
Oh, sorry, you haven't got that. Thank you.
So it says maintain appropriate records. So we've got reference about just And then in 4.8, it talks about informal action will be recorded on department files. And in, where else have I got it? And then it talks in 6.3 about keeping records in public registers. So I think there's a few references to keeping records. Yeah.
Councillor, you make a good point. I can certainly draw reference to the Data Protection Act and the other mention you say about the Equalities Act 2010. I can certainly look to incorporate them in the relevant sections for clarity.
Yeah. Okay.
Councillor Kane.
Thank you, Chair. I've got a couple of questions. One is on paragraph 2.24, which is on page little 7, big 43. It says we're going to endeavour to ensure that all parties are treated equally. I just wonder why we qualify it with endeavour rather than just we will ensure that all parties.
Okay, thank you, Councillor. Thank you, Councillor. Essentially, in that, the use of the word endeavour was inserted to cover the licensing authority from the risk of any sort of things which are outside of its control, affecting or preventing its ability to fulfil that undertaking. So, if it was an absolute, i.e., if endeavour was not placed in there and it was an absolute, then it could leave us open to essentially sort of appeals in that way for things which are outside of our control. So as a day-to-day undertaking, officers would look to ensure that all of those items, which obviously are largely protected under the Equalities Act, are being fulfilled. But it was placed in order, as I say, to mitigate any risks of things occurring outside of our control that might prevent us from doing that. But again, that was the thought process behind it. But again, that's for members to determine today.
And then my other question was about the section on RIPA, because we've as a council, we've just approved a policy specifically on RIPA. So my question was two parts. One, can you confirm that this is all compliant with the policy that we've just approved? But the other is more, why do we have it in here rather than just a reference to our policy? Because the danger is always that we'll update one and forget to update the other, and then there's some confusion over which applies.
Absolutely, Councillor. So in answer to those questions, the first part, I can assure members that this document, paragraphs 8.1 to 8.6, were run past our information officer and legal department, who actually, the initial draft didn't reference the Covert Human Intelligence Sources Act 2021, and that was obviously placed in. So I can assure members that has been resolved and they are happy with that side of things. With regards to why not just referencing the two policies that you rightly say are in existence, I completely understand that on one side that you do run the risk of having two documents out of sync with each other. On the other side, there's a having a one-stop shop for people to be able to look at the licensing authority's overarching policy. And for that reason, that's why that information was put in there. However, thinking about the implications you've raised, is we could, in paragraph 8.4, where it says that we will have regard to any policies and issues relevant, we could insert after policies a bracketed part which basically says words to the effect of the council maintains both a RIPA and specific RIPA and CHIS policies. Further information can be found at this location. That would at least direct people who are reading this document to the fuller document. But equally, again, I remain at the disposal of members if you would rather that 8.1 to 8.6 be removed and replaced with please see these locations, then I'm quite happy to go with that.
Would it be possible that
bracketed bit you're suggesting putting, would it be possible to also put in there that if there were any differences between the two, it would be the council's main policy that would apply?
Absolutely, that could easily be inserted too, yes.
Though there might be a way to make sure that if the main council's main policy is updated, then this policy is updated as well. Because otherwise it starts to get incredibly wordy and cumbersome.
I agree there should be mechanisms to make sure it happens, but with respect, this hasn't been updated since 2006. So you can have as many mechanisms as you like. Things happen, things get missed, and then you can find yourself with trying to enforce something that is unenforceable because one of our documents says one thing and the other says something else.
So,
Councillor Trapp.
So there's a tiny point of pedantry, but coming back to 2.2.
You shock me, John.
Coming back to 2.24, where it says we will. Will, in that sense, when it's for the first person, singular or plural, is actually one of intent and desire rather than actual command. So if it said we shall ensure, that means it will, we are going to we're going to do it. Whereas we will ensure actually says that's our desire.
It says endeavour, John.
Ensure, no, I'm saying
we will endeavour to ensure. So
yeah, but if we say we will ensure, then it has a thing about. So I'm just thinking about what you was replying to Councillor Kane about that will still convey the message that we're trying to do it. That is our intention. Whereas if it's we shall ensure, that it is absolutely de registe.
But I think Stuart was explaining that this was to take out the things that are outside of our control.
Yes,
we will endeavour to ensure.
Okay, all right. Well, we'll actually ensure we'll actually have that intent.
Well, yeah.
Okay, all right.
We'll argue that later, John. Does anybody? Oh, Councillor Wilson.
Yes. You said, Stuart, that you've taken Appendix A and B out, but you didn't. I couldn't find Appendix A and B, and I couldn't see what Appendix B was about.
I don't think it was labelled as B, was it? It was just.
Councillor, I refer members to page 24 of the report. It's got page 12, but it's got also page 24 in bold.
Yeah. And
at the top of the page 24, you have Appendix A, East Cambridgeshire District Council Licensing Prosecution Policy. So that's Appendix A. And then on page 27 is the Licensing Act 2003, the page starts. It states Memorandum of Understanding and Joint Enforcement Protocol signed between East Cambridgeshire District Council, and then it lists 5 other bodies that was signed with, but it states in that document that it needed to have been reviewed, and that was the document I referred to that would be best placed as a standalone document. It was
Appendix B, and that's why I couldn't spot it.
Sorry,
yes.
Yeah, sorry, it was Appendix A and B to the 2006 out-of-date policy. Sorry, Councillor, for any confusion.
Thank you.
Does anybody have any further questions of Stuart before we move to the debate?
Could I just say, Councillor Inskip, with regards to the going out for consultation on the document, just recently in Environmental Service Operational Services Committee, we brought both the updated reviewed housing enforcement and environmental crime enforcement policies. Both of those just came for adoption rather than consultation. And I think it's because within the enforcement policies, we are just outlining those options, and they just sit below that full enforcement policy that is adopted by the council. So on both those occasions, we just approved at committee rather than went out to consultation on those.
Yes. Okay, so we move now to the debate. It would appear that we are looking to add into at 8.4. That be correct, Councillor Kane? You would like additional words in 8.4?
Yes, please, Chair, as the officer suggested.
you happy for Stuart to draft the additional wording? And are we all content that it mentions the overarching review or the overarching enforcement policy? Or the RIPA policy? Is that what you want? I'm sorry,
The
I'm
RIPA and
getting confused.
Chips, is it?
Yeah,
Chiz, not chips. They were highway
That's right.
patrol.
You see, I'm hungry already.
I was thinking California and highway patrol. Sorry, we're digressing. So yes, so you want the Chiz and the Ripper. I think they'd come up with better initials, wouldn't you? Really? Yes, it's to mention that the overarching council policy as well. So I'm sure you'll be able to find the
Yes,
right
please,
wording.
Chair.
Yeah. Does anybody else have anything to say before we move to the vote on this? Councillor Inskip.
Just wanted to check also there were the two legislative references I made, whether those were going to be incorporated as well.
I can confirm, councillor, that I will go through line by line, and where relevant, I will place those in.
Okay, thank you.
Anybody else have anything to? Oh, Councillor Trapp. You want to put ensure in, don't you?
A minor point. Just as the piece should be capitalised, should it not be? In 8.5, justice.
I think you're correct. I think you are correct, John.
I am correct. I was thinking about this.
Are you ever wrong? Hard to say.
I'm always wrong, according to Caroline.
Harsh. Does anybody else have anything to contribute or say? Are we happy to move to the vote? So we're happy to move. We are voting to adopt the policy with the additional wording. And Stuart, you'll send that round to all members for their satisfaction before we so they can see that the wording is to their liking. So can I have a show of hands, please? All in favour? That's unanimous. Thank you very much. We can now move on to agenda item number 6, animal welfare fixed penalty notices, and I hand you back to Stuart.
Thank you, Chair. Okay, so this item is to update members on the new powers conveyed by the Animals Penalty Notices England Regulations 2023 and the accompanying statutory guidance which officers must consider when using the powers, we seek authority from members to consider the use of fixed penalty notices. So again, by way of background, in 2022, the Animal Penalty Notices Act gained royal assent and became law. As a result, the government ran a consultation exercise to seek opinions on whether the use of fixed penalty notices would be useful as an enforcement tool. The result of this consultation was that more than 85% of respondents supported the view that penalty notice could be a proportionate tool to ensure compliance with animal health and welfare regs. And they also supported the use of penalty notices to enforce regulations across different areas of animal health and welfare legislation. So these notices don't just affect what we do in licensing here, they affect those who inspect farms for welfare of farm animals and things like that as well. To facilitate the implementation, the Penalty Notices England regulations were introduced, and in December 23, the Department for Environment, Food and Rural Affairs, DEFRA, released statutory guidance to provide a framework for enforcement agencies to have regard to when issuing these notices. They can't be used for all animal-related offences. So the Animal Welfare Act 2006 has a list of offences. They range from suffering, which is sort of section 4, which is a high level offence, down to section 13, and which are your kind of breaches of the legislation that we look after, the sort of if you weren't running a boarding establishment correctly or a pet shop correctly, that sort of thing. You know, refusing to assist us with giving samples, taking samples from animals and things like that. So it has a range, but as I say, it's not, these fixed penalty notices are not available for certain offences that are deemed too serious to be dealt with via this way. The statutory guidance it's not a substantial document, but it does provide more detail around the areas covered by the 22 Act and the 23 regulations, and that's in Appendix 1 to my report. Now, a table in 4.1 essentially sets out the offences that are applicable to this council within my department's role. And you'll see there the Dangerous Wild Animals Act 1976. So that's people who want to essentially keep dangerous animals under Schedule 4. So that could be, alligators, polar bears, spiders, venomous sort of animals, that sort of thing. So they can come on there, and then the offence is listed in the right-hand side of that table. So keeping a dangerous wild animal without a licence, and obstructing and delaying an inspection by a local authority. Strange one, Animal Health Act 81, which is failing to use a collar on a dog in public.
Didn't know that.
Is an offence, and that would fall within the ability for fixed penalty notices. And then you've got the Animal Welfare Act 2006. So I've mentioned section 13, which is for offences about licensing and registrations of activities involving animals. But section 11, transfer of animals by way of a sale or prize to persons under 16. And section 9, which is the general duty on a person who's responsible for an animal to ensure that animals' welfare needs are taken care of. And then specific offences under the Animal Welfare Licence and activities involving animals regulations, which is failing to provide assistance with taking samples from animals, obstructing an officer, and breaching a licence condition. So that's the sort of range of offences that could be subject to a fixed penalty notice as a way to resolve an indiscretion. So the maximum fine level that can be imposed is £5,000, or the maximum that the accused could be fined if fined summarily in the magistrate's court for that offence. Fixed penalty notice must contain prescribed information. It's usual, it's the norm, there's nothing, say, unusual about that. But it basically states there on paragraph 4.3 the 5 items which they have to have. There's 28 days that they can pay, and effectively that doesn't impact on the period that we're allowed to bring charges, because that's what these are essentially. They are a way to dispose of a criminal act. They won't be used for civil acts. That will still be suspensions and revocations dealt with by this authority either by officers or in a committee. We can withdraw them at any time. So if we issue them, we can withdraw them. And we must take into account various factors. So seriousness of the conduct, the duration, the intent behind it. And the list there's 8 items there which that we need to take into account. The statutory guidance sets out how we go about the process of the fee, because the fine, should I say, because the fine is as I said, it is a maximum of 5,000 or the maximum they could be charged for and fined in a court. But it's based on harm and culpability. So if it's high culpability, high level of harm, then you go into a certain area where you can see that the fine would be far higher than if it was low harm and low culpability. And that's all within the statutory guidance that we have to have regard to. We cannot issue them unless we're satisfied beyond reasonable doubt that the person or the body corporate has committed an offence. So it's the same evidential and public interest tests required for prosecution must be met. They're not just to be given out because that's what we feel like. So that they are very much at the highest level of evidential and public interest test. We are not permitted to prosecute for a failure to pay a fixed penalty notice within 28 days. So councils would have to consider whether formal prosecution for the offence is necessary and appropriate in such cases. And I say that in the report because it's a pivotal difference between what most people understand of a fixed penalty notice. Most fixed penalty notices you can prosecute on non-payment of them, and go after that side of things. Whereas these are not a fixed penalty notice in that way. Effectively, if we do issue them, and the person decides that they do not wish to pay it, we have no powers to force them to pay it. We would have to consider taking the action to a court or arguably withdrawing the fixed penalty notice. But that latter option is clearly not going to be something we're going to do, because why would we have gone to that level in the first place? You know, so it is something to sort of that officers will be bearing in mind when we look to dispose of these issues. Okay, there's no right of appeal when we issue a fixed penalty notice. So we issue it, they either pay it and that resolves them of their guilt, or they don't pay it, and then we have to look at our options in that way. The fine level is reduced by 50% if they pay within 14 days. That again is a legal requirement. The costs incurred in the investigation of the offences that led to the issuing of a fixed penalty notice and the costs of issuing a fixed penalty notice can be deducted from the fine amount, but any residual sums must be paid into the government's consolidated fund. So they are not a profit-making option for the authority. They are very much a way to avoid the potential for court time to be used up. Annual reports must be provided showing the number of fixed penalty notices issued, the amount specified in the fixed penalty notice and the offences to which they relate. So that's a legal requirement on officers to fulfil that. By way of conclusion, the legislation doesn't require an authority to adopt the provisions of the Act like other legislation we have does. The legislation is written in such a way that it enables an authority to consider issuing a fixed penalty notice as an alternative to issuing a simple caution or initiating a formal prosecution. And that's been available to us since the 1st of January 2024. At this point in time, we haven't. We haven't clearly because we needed to come to members and to have your permission to go ahead. As pointed out in section 4.9 of my report, a council cannot prosecute for a failure to pay a fixed penalty notice. I've already gone through the reasons why. And officers do consider that the use of fixed penalty notices could be helpful with dealing with low-level infringements and would recommend members to authorise officers to be able to consider the use of fixed penalty notices. But we would point out to members that the inability to prosecute for a failure to pay the fixed penalty notice seriously limits the effectiveness of the powers provided by the legislation. So financially, the implementation of all of this will take time to implement and set up and populate the website, etc. But again, those fees are all paid in with the budget of the licensed authority in that way. As I say, there is potential income, but that income will be cost neutral, like many of the licensing fees that we charge, because, as I say, any proceeds after costs have got to be forwarded to the government in their consolidated fund. And as I say, there are no other sort of financial impacts other than that. So that's the end of my report, Chair. If there's any questions, I'm happy to take them.
Thank you, Stuart. Oh, hands going up everywhere. Trustee Ambrose-Smith and then Councillor Goodell.
We're looking at this from the point of fines and so on and so forth. So someone reports that animals are being kept in a poor condition. You go, yes, that's a bit, you know, that is the case. You're liable to be fined, this, that, and the other. What immediate action is taken? I mean, your officers wouldn't seize a litter of puppies that are clearly in need of proper care. That's another authority. I mean, you know, this seems to be, someone can be treating animal, from what I pick up here, someone can be treating animals cruelly or poorly for whatever reason, and we can fine them, but who actually takes the action?
We do, essentially, or we are one of, you know, the RSPCA can take action. But as members are aware, we have for the last 2 years been dealing with an animal welfare prosecution that was the result of this authority. So the Animal Welfare Act 2006 essentially authorises an authority. It could be the police, it can be ourselves. It's a sort of a common enforceable law. So any authority can. So the RSPCA can use it, we can use it, the police can use it. And we would, in the scenario you just said, where if we came across where a litter of puppies were in a really bad way and were not having their welfare needs met, then we would look to take them into our possession, and that would become our burden. And then we would then apply to a court under Section 20 of the Animal Welfare Act in order to say to the court, please allow us to, you know, essentially move these animals on to better places. And they hopefully would give us that permission to do that. So what we're looking at is, this is just another tool as such in the belt that we have. So if we go out and we find illegal activity is occurring, we would have a proportionate response to that. The response may be that the person is unaware, legitimately unaware that they need to have a license for the activity. You know, they'd only just strayed into it. They'd only just, you know, started to sort of go above and run it as a business, for instance. So we would look at the reasoning behind that, and obviously what we see when we go out. It's a proportion-led, which is obviously goes back to the previous item of the enforcement policy, in that we look at all these different avenues. And we would come to the final conclusion of saying, okay, this person has committed an offence. The mitigation behind that is such that we don't feel that it's in the interest for it to perhaps go to a court prosecution, but at the same time, you know, it is an offence, and it was serious enough to justify some other avenue. Now, that could be a simple caution, which is already available to us, or it could, with this new scheme, be a fixed penalty notice. You know, to essentially to obviously give a bit more teeth, because a simple caution is administered by us. There is no financial penalty to that. You know, it's a piece of paper that sits in the background. It's not a recordable offence, so it doesn't appear on enhanced DBSs and things like that. So, you know, they are useful for ourselves, because if that person comes to our attention again, we can bear in mind they've had a simple caution. The fixed penalty notice adds a financial sort of hit to the wrongdoing. But as I say, all the way through the report, you'll notice that it's all about that it has to still be satisfied that it's at the beyond reasonable doubt criminal threshold. You know, we are not just going to be issuing these left, right and centre, because ultimately, as I also pointed out, if people don't pay the fixed penalty notice, then we have that decision we have to make. And clearly, like I say, if we've got to the point of issuing a fixed penalty notice, we're not like many other authorities out there who are facing this same sort of decision. We are not going to back down and not take that forward. You know, and that obviously then creates a burden of work. So it's just another piece in our armoury, in our tool belt as such.
If I might just come back briefly. So the point is that some immediate action would be taken. The animals wouldn't continue in that poor state for 3 months while we decide, you know, what we're going to do about it and argue the toss. Someone will deal with the actual situation in a meaningful way at that point when you become aware of it.
Absolutely, Councillor. We would not walk away from any sort of animal that is suffering or not having its needs met. So at that point in time, we would take the immediate action. That's about the preserving the welfare and promoting the welfare of the animal side. What this is about is what we then do down the line as a disposal of that harm that was created by the person in the first place.
Thank you.
Councillor Goodell.
Thank you, Chair. Stuart's basically answered the question I was going to ask, which was about educating the people before we start fining them. You know, it's like someone had a dog outside without a collar on. Would you educate that person first and with the caution? And then if it happens again, the same person, then the fines come along.
Yeah, we haven't stated that we would, you know, on every first occasion give the person a chance, and then on the second occasion we would take action. Each case will be dealt with on its own merits, and if that first instance is so serious that it requires some sort of formal action, the formal action will be taken. The way to dispose of that will be then judged accordingly, whether it be a written warning, whether it's a simple caution, whether it's a fixed penalty notice, or whether it's a straight through to a prosecution. So there will always be that measured, proportionate response. But obviously, as I stated within the financial section about the work that's going to be involved, we will populate this on our website. You know, people will become, you know, more aware of the rules that are there. And essentially all this is, it's not really changing the offences. The offences have always, well, I say always been there. You know, the most recent ones were sort of 2018. All this is doing, as I say, is just giving us an additional way to dispose of it. And we will make sure people are aware of that on the website for everybody.
Thank you, Stuart. Councillor Wilson.
Thank you. The extra thing we've got is the fixed penalty notice. But presumably most of these offences, we're working fairly closely with the police or RSPCA or whatever. Will they have the power to issue a fixed penalty notice as well? And how do we work closely with them? And or do we, if they came up and said, look, this person needs a penalty, can you do the fixed, or somebody else has initiated the problem?
That's a good point, Councillor. The regulations, the 2023 regulations, in the list of relevant offences that can be actioned by way of a fixed penalty notice, there's a table within those regulations, and that table states the offences, the legislation should say the offences, and then who can enforce it. So certain offences are enforceable by the licensing authority, some by the police, some by other external sort of agencies. Essentially, if we're listed in ones who can enforce, we can enforce. If we can't enforce, it's then for the other authorities to enforce, and they would have to issue it. So the table in 4.1 I referred to earlier, they are the offences that we can issue on. We can't issue for anything outside of those, but the list is quite extensive. If you look in the regulations appendix, you will see a list that does reference a lot of other animal welfare related offences that will not come to us.
Thank you, Stuart. Thanks, Stuart. Councillor Sharp.
Thank you, Chair. Thank you for this, Stuart. Just one, and obviously you've said that if we're going to issue a fixed penalty notice, then we're likely to want, if they don't pay, we're likely to then want to carry it forward. Is the fact that we issue a fixed penalty notice, is that a civil offence or is that a criminal offence immediately we issue that? Presumably, if we take them to magistrates' court, it becomes a criminal offence.
So the offence is criminal. It has to be criminal in order for us to issue a fixed penalty notice. But the fixed penalty notice, the failure to pay is not a criminal matter. It's not actually even a civil matter, really. Use my words carefully, because a barrister who's quite renowned as such said it's almost a bit like a bribe. They're not my words, and I won't say whose words they were, but it is very much a bit like a bribe. You know, offer this and it will go away, or it will go to a prosecution, because the actual notice itself is not like a parking charge. It has no teeth on the notice, and this is why there was a reservation of saying this is not something that we're going to be issuing these left, right, and centre. They are there. They will serve a purpose, in my opinion. You know, but you know, they are not. They don't have the weight that I had hoped they would have had, which would have been that you could have been, the teeth really, that you could have actually prosecuted for failure to pay it. You know, so yeah, that's the issue.
Yeah.
Very quickly. Yeah, I understand that. It sounds like it hasn't got the teeth that possibly we would think, but presumably, and this is how you would enforce it, and I'm not telling you how to do it, but where you've got somebody who's come along and contravened whatever, they've been issued with a fixed penalty notice, they've paid it, and then a year later they contravene something again, you're probably not, we're going to think, hang on, we're not going to let them get away again. We'll take it maybe through the prosecution route, because this is something systemic with the way they're operating, rather than necessarily a slap. Or hope I can understand the thinking presumably behind the legislation is to try and give people a slap on the wrist of those who've contravened something not too major, and hope they don't do it again. Presumably, that's the thinking.
I would say that is probably their thinking. From our point of view, I would see this as just being on the scale, as I say, that we have like no further action at this end, and we've got prosecution at this end, you know, and these will slot in sort of towards the higher end of that scale. Probably, to be honest, you know, not quite sure exactly where, but probably simple cautions and then fixed penalty notices, but they're going to be at this end of the scale. So that's where I see them fitting in. As far as what happens if we issue, somebody pays, and then 6 months or a year down the line, then with our proportionate response, we wouldn't look to issue another fixed penalty notice if a fixed penalty notice has clearly failed to do what we intended it to do, which was, like I say, dissuade and change people's attitude. So in that way, we would, as I say, look to for the next level up in that way, which is essentially what we do largely now with our general approach to enforcement.
Councillor Trapp.
Thank you. You seem to have answered most of the questions I had. But you were saying about the second fixed penalty notice, one could actually say make it higher. So if the first one of £500 didn't work, the whole thing looks to me as if it's trying to save time in the magistrate's court. And as you say, it's a bribe saying, right, we'll just give you this, and then we don't have. But now about costs, I mean, you say this is going to be sort of net zero, but things like costs to the magistrate's court, surely you have to brief a lawyer and things like that, probably, do you, or do you not? I mean, would that be a cost that could be counted into this? So it could be defrayed by some fixed penalty notices if you have to take someone to court.
Okay, so Councillor, with regards to the cost neutral side of things, is that we can deduct the costs of the investigation. That will include legal support. You know, that can all be taken into account up to that point. And as it say, and the issuing of the penalty notice as well. So if we had a centralised system that generated that for us, and they provided a cost to us, then all of those costs can be taken into account. But none of the nothing beyond the issuing can be taken into account. So if an investigation from start to finish cost us, you know, £700, let's say, then if when we looked at culpability and harm in the table and for that offence, we may well find that that £700 exceeds the level of the fine that we were able to give in the first place. So obviously we would give the full fine, and we would keep that full fine because we've actually made a loss on that prosecution, on that fixed penalty notice, should I say. If it was to be the other way, then we can only deduct the cost of the investigation up to the point of issuing the fixed penalty notice. And everything beyond that would have to be sort of kept to the side and sent to the consolidated fund. We can't take into account anything sort of beyond that if we then subsequently go on to prosecute formally and have to go to the court and all that cost.
Isn't that on a case-by-case notice? So if we lose on a fixed penalty notice in one case, can that be defrayed by profit? I'm putting this in a business sense, by profit on another fixed penalty notice, or is it just per case?
I love the argument for that one. Unfortunately, they are looked at on a case-by-case basis. So, you know, we would look, and obviously certain costs, joking aside, obviously, as you know, from when we go to the fees review and everything, some of our costs are very difficult to attribute to a single action. So in that regard, there will be a degree of combining of the costs within the scheme. But no, when it comes to providing the reports, I need to be able to sort of separate out and say, you know, as it said in 4.12, providing the number of the FPNs that we've issued, the amounts which were on those FPNs, and what offences they related to. And for that reason, you know, I would also then have to substantiate why the level was that level. You know, so we will need to account on a case-by-case basis.
Further question. Do you think this will reduce your workload or increase it?
My gut feeling is that it's not really going to have an impact either way. I think that we're a responsible authority, and we won't, as I say, be looking to just issue these fixed penalty notices at the drop of a hat, you know, which potentially then leads people to not agree with being issued a fixed penalty notice, which then leaves us in a situation of having to prosecute, essentially. You know, and that would have implications on the licensing authority, it would have implications on the legal department, you know, et cetera, et cetera. So for me, I feel that, you know, we will go about doing what we do on a daily basis, just like we always have done. You know, and rather than issuing a simple caution, we'll just issue a fixed penalty notice, and that may or may not be paid. So a small potential for an increase in workload, but I would hope not a substantial one, is probably my gut feeling.
Presume, sorry?
Could I just add to that?
No,
sorry. From a manager's point of view, the way I see this is, as Stuart has spoken about during his presentation, is that this is another tool within the box to enable us to actually deal with issues that arise. For every single one where we're contemplating or looking at the issuing of a fixed penalty along with it, we will still have to put a prosecution file together. So there will still need to be that work done in the background, one, in case the notice is not served, but also is when we are looking at that prosecution file, we don't feel that the fixed penalty notice is actually sufficient, that we will need to go to court. But where a fixed penalty notice is considered to be maybe the best course of action in this instance, that may reduce the amount of time that would then mean both legal and Stuart spend in going to court to do that bit. So it will be interesting to see how it works out. But from my perspective, I think there is a potential for it to reduce the amount of resource of getting somebody to actually realise what they've done, pay the fixed penalty. That means we will get our costs covered. The majority of it may well go, you know, back to someone else. But I could just see that it allows us that opportunity to deal with an individual in a different way.
Okay, and can I carry on? Councillor Wilson has spoken already once.
I'm a very generous chair, John.
We will get a report then on the preceding year, shall we say, how many fixed penalties to this committee.
It would be included in the annual fees review report.
Okay, thank you very much.
Councillor Wilson, your second bite of the cherry.
Thank you. I was just wondering how many of these we expect to get, because at the moment you presumably do warnings and prosecutions. How many of those happen in an average time?
So the level of indiscretions, let's say, amongst our licensed trade, who are legitimate, licensed, have their annual inspections, have their unannounced inspections that we do, our compliance level is very high. We don't have I cannot honestly think off the top of my head of anyone who would be somebody who would pop instantly into mind of thinking, yeah, this could be a potential sort of, you know, carrot situation or whatever here, you know, this could warrant it. So on our existing stock, I don't see any issues there, you know, and need to use it. I think these will be for new people coming along, or new people being found out, and more than likely the latter of those two. You know, the ones where we get reports that people are doing X, Y, and Z. You know, I think it will be that sort of thing. So whilst we do, as is in that table, have the option for issuing these for obstructing officers or breaching licence conditions, as I say, we're quite fortunate. We do have a highly compliant trade, and for that reason, I don't see a large number of these being issued by this authority, to be honest. We don't, as an authority, have a large number of prosecutions within the licensing authority generally. I know we have got some going on at the moment, but we don't generally have. So I don't foresee a lot of these being issued. I think they're just having them in the armoury is something that will be useful, but they are of limited means.
Thank you. Does anybody have any further questions for Stuart? Right, can we move to the debate? Does anybody have anything further that they want to contribute in terms of debate? Councillor Inskip.
Well, I don't really want to prolong the debate because we've had lots of questions. I think actually, I just to say, I think it's a little bit. I can see the benefit of adding this, but I think that inability to recover if the payment isn't made, I think limits that. So I think I can see the benefit of having a middle way between a caution and a prosecution. But it seems we're rather in the middle, we're just a little bit up from the cautions. But I have no problem at all with, let's say, adding this to the licensing armoury. Just on the other point I would make is whether we should be doing anything as an authority to maybe publicising some of this legislation, because I think there were one or two comments earlier on about the requirement, for example, for dogs to wear collars in public places, which dates from 1930, so it's not something that's just appeared. So I just wonder whether there's also that sort of education piece to make sure that residents are aware of some of these things that maybe they aren't familiar with.
Indeed, Councillor. We work with comms. And certainly on this, once I've got the web pages populated with the information, I'm sure we can do something with comms to raise public awareness of it.
Yes, thank you. Just to reassure Councillor Inskip, I think any fixed penalty notice is only issued if it can be proved beyond reasonable doubt that an offence has been committed. So more or less, I would suspect it will go to prosecution if the offence is not paid, if the fixed penalty notice is not paid. Otherwise, we wouldn't be doing that in the first place.
Indeed, Councillor. You can never look into the mind of somebody who's done something wrong. But hopefully, if we were at the point where a fixed penalty notice had been deemed the appropriate sanction, that person would be instructed to take independent legal advice, and we'd be hopeful that solicitor would advise that it is in their best interests to settle matters, because it's not a case they're going to win if they go to court. You know, so hopefully that's how it will pan out, and we will be issuing them responsibly. As you say, you know, if they don't pay, it will have to go to a prosecution. Otherwise, like I say, it's not right.
Does anybody else have anything further they want to contribute before we move to the vote? Excuse me, I'm frog in my throat this morning. Right, okay, so we are requested to note the report and agree that officers may consider the use of fixed penalty notice when determining the appropriate level of enforcement action to be taken against any person, body, corporate, who they are satisfied has committed an irrelevant offence. Can I have a show of hands, please? That's unanimous. Thank you very much. Now move on to the forward agenda. And I think our next meeting is on the 11th of June, where we have the 19th of June, I beg your pardon, 19th of June, where we have the Gambling Act 2005 policy consultation. Oh, what have I missed out? Oh, I beg your pardon, Stuart, I've overgone you. You can, John. I probably won't pay it, but there you go. Stuart, over to you. Beg your pardon.
Thank you, Chair. It's a short and sweet one, really. At the moment, we've been receiving almost unprecedented levels of work, it seems, in the department. We are being approached by a number of taxi companies who are looking to expand in this area of the country. And I say this area, not specifically East Cambridgeshire, but the east and southeast of the country, predominantly working in the special education needs contract area. Some of these companies are approaching us as far afield as Newcastle, and they are looking at various options for their licensing. Obviously, they have operations in other areas. In order to be able to operate fleets more local to where they're trying to expand into, they're looking to obtain a local licensing authority to do that. We've been approached by a number of them, and one has put in an application, for a new operator license. So that's sort of going through. So it's just to make members aware of that, and more information will come available on the impacts that that's going to have on the department moving forwards. Unfortunately, the animal prosecution we had, sentencing was adjourned because they couldn't get a district judge to hand down the sentence. So we all arrived at court, and at the 11th hour, it was adjourned until May. Again, once we get to May, and hopefully, fingers crossed, we do get the judgment, and we'll report that back to members at that time. We've just obviously gone through year end, just to make members aware that all of the year end financials were submitted to the finance team in time, and obviously that information will be taken into account when we look at the fees review later in the year, and all of the annual reports that we have to provide for Gambling Act returns, animal welfare returns, and Licensing Act returns have also all been provided to the relevant agencies that need to see that. So we've satisfied all of those needs as well. And I think that's it, other than, say, sort of business as usual, really, but very busy at the moment.
Do you have any note about the appeal of the London
Garage? The appeal at this point is still, yeah. So members may be aware that the subcommittee made a decision to revoke a premises licence for Londis, and at this point in time, basically what we class as a without prejudice offer is between parties and the court. To enter into what will eventually turn into a consent order that is to the satisfaction of both parties. So again, once that has been concluded, that will be reported back to members at a future committee.
Thank you, Stuart. And now Councillor Goodall.
Thank you, Chair. Stuart, I've heard through the grapevine that CPCA we're going to take on the role of taxi licensing at some time. Is that still in the pipeline, or has that been kicked into touch?
No, Councillor, you're referring to the Levelling Up and Regeneration Act that had a small part in it that talked about moving taxi licensing, private hire licensing up to upper tier councils where they exist. And in our area, that would mean the Cambridge-Peterborough Combined Authority that would be given powers to essentially issue all taxi licenses within that larger area, which would obviously bring into it Peterborough City Council, Cambridge City Council, South Cambs, Fenland, ourselves, and Hunts. Would all fall within that, and everything all taxi would relate and shift up to that upper tier. But it is still out there. You know, the LGA have consulted with all of their member organisations to see what the general feeling was. It was pretty much unanimous that the councils at this level, district level, who currently enforce and deal with it, are against that proposal, as it would take away a lot of local control, local knowledge, local enforceability. It also has the potential in a larger area that you may get migratory factors where some areas will get no service at all and others will get an abundance of service and things like that. So there's a lot of things. It is something that, as I say, hasn't gone away. There will absolutely be full consultation if that does gain momentum. You know, so we're just going to watch this space really. But if it happens and it's the will of the government for it to happen, then we'll have to respond accordingly. But we just have to continue as we are, you know, and deal with what we're dealing with on a day-to-day basis.
Carrying on with that then, on the assumption that the combined authority wouldn't have the in-house experience and capacity to deal with that, would they then subcontract the work back to the various authorities? Would that be allowable or possible?
I think under the legislation, I think that would be possible. But what you have as well is obviously we've got our kind of sovereignty and our committee structures and all of that side of things, as well as officers established. And in order to fulfil this new requirement, you would have to have that established at the combined authority as well. And as you say, there's only a certain degree of talent around who are used to dealing with taxes and all of that side of things as well. And then are they going to be dealing with the enforcement almost on a daily basis? Because, you know, you could be looking in that combined authority area at 25, 30,000 vehicles and drivers, you know, quite easily. Yeah, you know, so there are major implications, you know, for doing it. You know, we just, as I say, we're just going to watch this space really.
Thank you, Stuart. Now we move on to the forward agenda. All look surprised. The next meeting is on the 19th of June at 10 o'clock, and there we will be looking at the Gambling Act for the policy consultation, to go out to consultation, and anything else that comes up in between will be added onto the agenda. And if we have nothing else to contribute, I will draw the meeting to a close at 11:06. Thank you very much for coming.